Will Duffield, nice to have you on Underscore today.
Great to be here, thank you.
Yeah, for sure. We're here to talk about big tech, social media, and Section 230, the bad guy of the year, right, when it comes to anybody on either side of politics.
Keeps everyone online complaining about it, that's for sure.
I cannot wait till we never hear about it again, but until then, you're going to break it down for us. Big tech, Silicon Valley, the FANG companies, Facebook, Google, Amazon, Netflix. I'm old enough to remember when they were beloved almost by everybody. They were celebrated as breaking barriers, making the world smaller and more unified. The left really enjoyed them in the years of Barack Obama. Today, they don't have many friends left in Washington. What changed?
Well, to a large part, Donald Trump was elected president in 2016, and he used their tools very effectively in order to get his message out there. For many of his supporters, they were able to speak to one another, network, and organize in ways that they hadn't been able to before, having been denied mainstream media platforms. In many ways, we saw what had happened in the Arab Spring come home. So there's a real shift in elite sentiment concerning social media.
The Arab Spring, I remember watching it. I was visiting D.C. I was at a hotel, and we were watching everything go down on the television there. I was going to go out that night, but we just sort of decided to watch all of this breaking news and watch Anderson Cooper get punched in the face out on the street. There was, in general, a huge amount of optimism surrounding what was going on there. This was the people accessing a new tool to tap into new forms of government, overthrow certain governments that were oppressive. And then we saw at the end of it that it just was not really working out for democracy. This was not a pro-freedom movement that we were seeing. It was just a movement of the people. You think that social media companies are looking now at the country in which they have put out these products and gone, oh, we didn't think those people would use it?
I'm not sure if we're thinking of social media firms themselves or more the Samantha Powers of the world. Mm-hmm. Folks celebrating the use of these tools to overthrow unwanted regimes that perhaps through control of media or a police state had been able to escape mass criticism for a long time, finally feeling the brunt of it. But again, when that sort of thing happens at home, it looks very different. It's coded very differently. At the same time, the Russian intervention or interference in our 2016 election has sparked a lot of concern as well. It's very difficult to say that it had any kind of real impact. The sorts of media being promulgated by these Russian troll farms was frankly less effective or less well developed than most of what Americans were already
at risk
creating.
of throwing us down a side road, like the coverage by the media of the Russian interference is the interference, right? Like that is the strategy. In a large part,
for the Russians, if they can get that to be the conversation, then they have won because they've delegitimized the result of the election. Whether or not they change any votes, if they're seen to have changed votes,
and
that's
I kind of wonder,
need.
like Mark Zuckerberg, Jack Dorsey, pick your CEO of these major companies. I feel like they always had a sense of the product that they created, that it could be used for good or for ill by anybody. But the employees of these companies maybe were really idealistic about what the ends of their company was. You see this with the Google reaction to the 2016 election and the town hall that they had. These just sort of starry-eyed millennial employees in their little googly spinny hats, realizing oh, this isn't just, some sort of progressive hub and mission that we're operating here. We're running a search engine and a company for anybody who wants to use it.
Well, I don't think the surprise was wholly novel. Boz had in the past written internally about misuses of Facebook tools. You've got many of these staffers working day and night on content moderation, kind of attempting to eliminate the worst of the worst content being posted to Facebook. So I think they were well aware of how it could be used, but at the same time, they were invested in this election, most of them Democrats, and there's probably a sense of complicity in a result that you don't like waking up November 6th.
I think complicity is definitely the right word. And you hear that thrown around. or that word thrown around a lot on the left when it comes to these issues. Section 230 of the Communications Decency Act comes up pretty often in this new debate over regulating social media companies. What is it, and why are we hearing about it so often and suddenly?
Section 230 prevents social media firms, platforms like Google, Facebook, etc., from being treated as the publisher or speaker of whatever their users post. So they, as an intermediary providing the platform, aren't held liable for user misuse.
Isn't that just sort of a single blurb of Section 230? What was it originally meant to be applied towards? Because this is all new platforms, internet companies, right?
Well, the overall Communications Decency Act that it was a part of was in large part an anti-pornography statute, imposing duties to age restrict and filter, if not outright remove, certain sorts of adult content, with Section 230 sitting as a kind of counterweight, Good Samaritan clause, empowering firms to moderate their digital fora as they saw fit to. However, the Supreme Court removed the rest of the Communications Decency Act in ACLU v. Reno, ruling that the imposition of credit card-based age restrictions on whole swaths of potentially adult content would filter all sorts of lawful and even non-pornographic content as well. Originally, it was created or added to the Communications Decency Act because of a pair of legal cases from the mid-90s. First, you have Cubby v. CompuServe, in which a forum provider, kind of old-school bulletin board called CompuServe, was held non-liable. They weren't treated as the speaker of some comments posted or a newsletter posted on their bulletin board because they didn't make any pretense of moderating it.
Yeah.
They didn't claim an ability to search through and remove infringing content or libelous content.
That's interesting. So they never made an effort to say that we have moderators. But a lot of these modern social media companies, they drive home every day. We have moderators, hundreds of thousands working on this. So they're almost setting themselves up to fail.
Well, right? This is why you got 230, because on one hand you have this Cubby CompuServe case, where Cubby's let off because they don't moderate. And then a couple of years later, on a Prodigy bulletin board, someone claims that the Wall Street firm Stratton Oakmont, later of Wolf of Wall Street fame, is a fraud and is about to fail. In retrospect, we might view this claim differently, but
slightly credible.
Yeah, but at the time it was seen as outright libelous, and perhaps an attempt to manipulate market prices as well. And Prodigy, unlike CompuServe, attempts to moderate its forums. They ostensibly require all users to use their real name. Now, in this case, the account used to spread these rumors was a stolen account, so the fact that they had a real name policy kind of worked against them because it lent an air of legitimacy to this false message, which perhaps we should keep in mind as we think about anonymity protections today. But in this case, because Prodigy ostensibly moderated the forum, they were held liable. Okay. They were treated as the publisher of this. And Ron Wyden and Chris Cox in Congress saw this as creating a perverse incentive. You have, on one hand, in CompuServe, a case in which, because you don't moderate, you don't attempt to clean up your forum, you're indemnified against user-generated content or claims arising from it as something like a conduit. Where on the other hand, if, like Prodigy, you hire moderators and you try to put in word filters, well, you're treated like a publisher and held to this stricter standard of liability. Yeah. So if you
try
make
to
an
do
effort,
well, then you actually can set yourself up for huge consequences.
So why would anyone try in the face of these two cases?
Well, I want to ask you about what I think is more of an odd way in Section 230 and how it's played out with publishers is Airbnb. and the use of Airbnb, short-term rental space, and how they've factored into Section 230 debate. So we've seen cities attempt to sue Airbnb. San Francisco, I think, is the best example for listings in cities where short-term rentals are banned or just heavily regulated. Is there something to be said for critiques of Section 230 absolutism that shield companies when they flout local governance, like San Francisco, aka like the will of the people? Like San Francisco decides they don't want short-term rentals. Airbnb kind of facilitates it being able to happen on a black market. Like, we don't like that. You and I are libertarians of sorts. Like, we want a free market approach to that. But if San Francisco decides they don't want it through the city council, then Airbnb is kind of messing up their locality.
It depends on whether you're viewing it as, or 230 as, a protection for speech or perhaps commercial activity more broadly. I think some of the Airbnb cases, depending upon how the laws are written, are more edge cases because they implicate Airbnb's role as a payment processor as well as simply a host for these sorts of listings. But when you get into some of these other commercial speech facilitation cases involving 230, something like Daniel v. Arms List, you have what looks like a more traditional Craigslist-style bulletin board. People literally posting classified ads the same way they might in the back of a local newspaper. That looks much more like speech and something that traditionally, at least, we restrict the ability of local jurisdictions to regulate.
Yeah, I mean, I guess I would be surprised before all of this mess started to hear that Airbnb could be treated the same as a Facebook or forum type platform when they're just offering you, rental space, right? And it kind of goes back to the Craigslist.
It's the question of who's offering that space, who's offering the product in question. If they're hosting an advertising space or a kind of bazaar for others to bring their products to, they aren't going to be seen as liable in the same way as perhaps if they were the seller themselves of the housing.
I think it goes to how many people in the free market movement think of market activity as a form of speech itself. Like, we sort of believe that that is a form of expression.
Well, and prices as these knowledge signals, definitely.
You're defensive of Section 230 as is,
oh, definitely.
Right? I mean, should there be any changes to Section 230 that you think would enhance the spirit of the law or make the internet more functional, more open, and free?
We could roll back FOSTA.
What is that?
So last year, Section 230 was amended with the idea being that this would prevent sex trafficking and prostitution.
This goes back to the Craigslist example, right?
Well, or Backpage
Yes.
as kind of perhaps a bad actor in that space, though also a space in which these sorts of listings were collected, a central repository that law enforcement could pretty easily query. But the effect of FOSTA in creating uncertainty around liability for things like Craigslist Personals has led Craigslist and similar sites to simply remove classified personal ads entirely. And as such, sex workers or prostitutes who previously relied upon these spaces to screen potential clients. Obviously, this activity is illegal, but that doesn't mean it should be legislated to be as unsafe or dangerous as possible, and effectively driving women off of the internet and incentivizing them, pushing them to go back out on the street.
The street corner.
Well, and then you're leaning in someone's car window as you're negotiating the transaction, instead of doing that from behind the safety of a computer screen, where you potentially have access to bad date lists and commentary from other clients.
Yeah, no, I mean that's an incredibly real and tricky issue, and it's kind of interesting how you can get from like the sex work debate whether or not you want it to be like safe, legal, and rare, or just accessible to the internet. These platform debates as well. I mean, that's an intersection I wouldn't have expected initially.
Well, so often when we're thinking about 230 and what goes on these platforms, it and they are treated as having created what they reveal. The internet renders a lot of human activity transparent in a way that it wasn't before.
That's scary.
Well, it is, but it can allow us to grapple with the full extent of some of these problems. When the drug transaction isn't happening behind the Wawa or whatever, but instead encoded in bits as it's happening.
Yeah.
You can appreciate the scale of transactions.
Will, there's a handful of reforms that are on the table when it comes to Section 230. They are coming from the likes of Josh Hawley, Senator Lindsey Graham. Those are the Republicans. You can name some Democrats as well, I'm sure. But there is a confluence of Democrats and Republicans coming together on this issue. That doesn't bode well, I think, for Section 230 remaining the same. What proposals are out there that you find kind of the most troubling and possibly the direction in which this will go?
Well, first of all, I'm not as worried, perhaps, as
I'm relieved to
others.
hear that.
Yes, there are a lot of knives out for 230 at the moment, but they're out for very different reasons. The complaints that Republicans have with 230 are, in many cases, the mirror or opposite of what rankles Democrats about the statute. What is to Democrats an allowance for hate speech, concern that these platforms allow people to say vicious or cruel things. Republicans would change 230 on the other hand in order to prevent platforms from limiting the sorts of things that people can say. Perhaps you hear a First Amendment standard bandied
and you
about.
think those are irreconcilable differences?
I think in any one piece of legislation there are, which limits what may get to the floor. An approach recently taken by Senator Lindsey Graham and seemingly supported by Attorney General Bill Barr obliquely comes at 230 on child safety grounds. And this is perhaps one of the few spaces in which you could see something move, because who's against child safety? But in a way, it seems like a way of getting end-to-end encryption rather than any real speech result. At present, Bill Barr, or the Attorney General, doesn't have any real authority to limit companies' provision of end-to-end encrypted chat. That's chat that the company itself doesn't decrypt at any point in its transmission. So I'm sending you a message, it's encoded on my end, sent as gibberish to you, and only you have the keys to decode that. But there are often law enforcement concerns that terrorists or other sorts of criminals are able to use this and can't be tracked.
Barr just sued Apple again, right?
Exactly.
Yeah, over a terrorist's phone.
So this bill proposed by Graham would condition 230 immunity on companies following some code of best practices around child safety. And that code would be created by the Attorney General in concert with a group of law enforcement and technical experts. It seems as though, as drafted now, the sort of law enforcement and child protection side of this proposed board would be able to have quorum on its own, and the Attorney General could therefore create whatever restrictions he wanted or requirements for these firms under the guise of child safety, and then condition their current business model on their complying with it. That could include an end-to-end encrypted communication.